Good morning. This is Haley Solomon with the North Carolina Housing Coalition. Thank you for joining us this morning for our housing call. And without further ado, I will turn it over to our Director of Housing Policy, Stephanie Watkins-Cruz.
Good morning, everyone. I hope you all are having a great week so far. We're going to go ahead and kick it off. I want to dive in. We have a special guest today. We'll be talking with Daniel Siegel from the ACLU. He's the Deputy Legal Director there. He has a broad civil rights practice with a focus on the rights of incarcerated people. Previously, he worked with North Carolina Prisoner Legal Services, Barrington Smith, and the UNC Chapel Hill Office of University Counsel. Dan also served as a law clerk to Justice Sherry Beasley at the Supreme Court of North Carolina. He is a proud double Tar Heel. He earned his BA and his JD from UNC Chapel Hill. Welcome, Daniel. Thank you so much for joining us this morning.
Hey, good morning. It's a pleasure to be here.
So going to go ahead and, kick it off. I know that we'll be talking about just your legal perspective on the Johnson versus Grants Pass case. But before we do that, could you tell us briefly about your role at the ACLU and sort of what it entails?
Sure. So the ACLU of North Carolina is a nonpartisan, nonprofit civil rights organization. And what we do is litigation and advocacy and public education on a wide variety of civil rights issues, everything from the First Amendment to LGBTQ rights to a lot of stuff involving the criminal legal system. And my primary role is to litigate cases in state and federal court on those issues.
Wonderful. Thank you. Can you give us a general overview of the Johnson versus Grant Pass case? I know the decision was released last week, but for those that maybe are just kind of jumping in, or for those that have kind of been in shock, I think like I have, just kind of refresh our memories on the case. What was being asked of the Supreme Court to decide, and kind of going down that rundown of the case?
Sure. So this case concerned a local ordinance that was enacted by the city of Grants Pass, Oregon. It was called an anti-camping ordinance. It made it unlawful to basically sleep outside on public property at night. And the plaintiffs in this case were unhoused people who said that this was unconstitutional and violated the Eighth Amendment because unhoused people who are sleeping outside at night are not doing so voluntarily. They're doing so because they have nowhere else to go, and everyone needs to sleep, and you should not criminalize truly involuntary conduct. The city said, no, that's not what we're doing here. This applies to everybody, and the city needs to be able to control who is out on public property, especially at night. And what happened at the lower court level was that the district court and then the Court of Appeals for the Ninth Circuit agreed with the plaintiffs. It said that enforcing this law would be a violation of the Eighth Amendment, which prohibits cruel and unusual punishment. The city appealed to the United States Supreme Court, which had not addressed this kind of issue before, and the city was basically asking the court to say that it does not violate the Eighth Amendment to enforce a generally applicable camping ordinance. It does not just apply to unhoused people, it applies to everyone. That was the main issue that the court was deciding.
And can you talk through some of the arguments? We know this case was heard, April 22nd. They had their oral arguments, so about two or 3 months ago. What were some of the arguments made on either side?
Yeah, so the plaintiffs, the unhoused people, their main argument was based on older Supreme Court cases that said the government can criminalize conduct, voluntary action, but it can't criminalize a status, just someone's way of being that they have no real control over. And so, for example, the status of being addicted to drugs or being an alcoholic, those are statuses that people don't always have real control over. It's totally involuntary. And the same, that principle should apply here. If someone is homeless, that is not, it's also not a choice, and everyone has to sleep. So if you don't have a shelter and it's nighttime, then people, being human beings, have the natural biological function of sleeping, and they don't really have a choice. They have to just lay out a blanket, lay down on the ground, and go to sleep. It is involuntary, and so it's something that the government shouldn't be able to criminalize. The other side said, no, no, no. This is different from those cases because people are still making the choice, somewhat voluntarily, perhaps not to be homeless, but to be on public property and to, lay down and go to sleep. And this is not a law that is criminalizing just the status of being homeless. This applies to everyone. This applies to if there's like a backpacker who sets up, a tent in the middle of public property, anyone else, any person who is, quote unquote, camping at night on public property would be subject to this law. Those are the basic arguments. And the outcome, the court ruled 6-3 in a decision that was along party lines written by Justice Gorsuch, accepting the Grants Pass primary arguments that, at least under the Eighth Amendment, that is not a prohibition on this kind of law. It is generally applicable to everyone, and the city has a bunch of, in the court's view, compelling reasons to enforce this kind of law, and it acknowledged that the issue of homelessness is widespread and complicated, and it's not for federal courts to get involved, at least in terms of the Eighth Amendment.
Thank you. That probably was the most concise summary I've been able to hear of this case. So you already kind of, talked about the decision. The Supreme Court did rule in favor of Grants Pass. What do you think this means from your perspective moving forward for the field of, housing and homelessness, but also for local government?
So I think it's important to focus on both what the court did say and what it didn't say. So first of all, the court did not say that states and towns and cities have to criminalize people being homeless and sleeping outside at night. It also didn't say that if there is this kind of ordinance on the books, that it has to be enforced. Local governments still have plenty of discretion to adopt ordinances that they think are appropriate and to enforce or not enforce ordinances that are already on the books. In terms of advocating for the civil rights of unhoused people, this case only has to do with the Eighth Amendment. And it is true, for many years, the Eighth Amendment has provided an important protection for unhoused people, and now that protection is gone, at least in this particular context. But the court acknowledged, and the dissent also acknowledged, that there are other legal protections and constitutional protections for this kind of situation that this case doesn't address. And so I won't get too into the weeds on it, but people have the right to due process under the 14th Amendment. They have other protections, perhaps under state law, and those might, if those are litigated and brought before a court, that still might protect homeless people from being criminalized under these kinds of ordinances. Right now, we don't really know. This is a conservative Supreme Court. They are not terribly friendly to civil rights, other than gun rights and religious freedom rights. But at least it is left for another day whether there are other constitutional provisions that, if someone brought a challenge under the 14th Amendment to this kind of ordinance, they might be successful, and I hope they will be, and I'm sure that we'll be seeing those kinds of cases pop up. But at least under the Eighth Amendment, this is not a protection anymore that civil rights litigators like myself would be able to point to in court. We're going to have to find a different way.
Okay. Thank you so much. I know for those that went to our Bringing It Home conference, Daniel was on our panel about this very case. We're still waiting for this decision. And Daniel, you made a lot of great points on that panel. Just want to offer you any other kind of key takeaways or words you want to leave listeners with as we continue to process this decision and think about how to move forward?
Well, I just know that anyone who cares about these issues is probably feeling pretty bad right now after this decision. I certainly am. But it's not the end of the road. There's still a lot of room to make progress in advocating for homeless people and working to solve this issue, both in terms of fighting in court and advocating in legislatures and especially what local governments can do. So it was a bad day when this decision came down, but we live to fight on.
Thank you so much for joining us, Daniel. I hope you have a great rest of your day.
It's my pleasure. Thank you so much.
All right, everyone. We will make sure to include the notes from our discussion with Daniel, the Deputy Legal Director from the ACLU of North Carolina, in our call notes. Going to go ahead and just give a brief overview of some of the remaining updates that we have for you today. For those that celebrate, it is the beginning of a new fiscal year for our local governments. My inner local government nerd had to say that. So the new fiscal year started for our state and for local governments across North Carolina yesterday. So it is a new fiscal year. Federally, there have been several new efforts announced recently to increase the supply of housing. They were announced by the Department of Treasury as well as the Biden administration. The Treasury announced new funding and a new rule to expand affordable housing with $100 million to expand affordable housing over the next few years. And then an additional $85 million was awarded to reduce barriers to building affordable housing and increasing affordable housing supply. At our state level, last week was a very busy week on several fronts, both federal and state. Last week was a whirlwind. They passed about 33 bills last week, most of them on Thursday, which was June 27th, and it was the final day of votes. They did not, however, manage to pass a budget adjustment that would have addressed the state's $1 billion budget surplus for the fiscal year that began yesterday. They did adjourn the 2024 regular legislative session on Friday, June 28th. And as part of their adjournment resolution, they have a list of all the dates that they'll reconvene and what they'll be able to talk about. Just want to highlight a few of the bills that made it, as well as things that we're still keeping an eye on because they're still a concern. So if you were on the call last week, you heard us talk about Senate Bill 630, which included a proposed constitutional amendment that would set a cap on the personal income tax rate and bring it down from 7% to 5%. It did not advance out of the legislature on their final voting day. It did make it out of the Senate. It did not make it out of the House. There are already corporate and personal income tax decreases that are set to go into effect in 2025. And so just the main thing that we want folks to take away from this is that, yes, proponents of the bills are saying that this will help protect businesses and households, but we know, and economists are already seeing that the folks that are really impacted by these types of policy decisions are really low to middle income households. They are more likely to feel the impacts of these tax policy decisions on several fronts. From the housing front, when you are already in a situation like our state is, where we do not have a state resource that is adequately filled or does not have the adequate amount of funding to really meet the need, and you begin to chip away at revenue sources that could go towards allocating or raising that resource that needs to be raised, it kind of hinders your ability to make larger investments and to really address issues that our entire state is facing. So we're going to keep an eye on that. It is likely that constitutional amendments won't get discussed again till around October or November. But what we learned last week, which is not a new thing, is that There's several different pieces of other bills that we may not like that could make it into bills that are seemingly mundane or normal. I'll give you two examples. There's Senate Bill 445, titled Recording of Court File Documents. It did make it out of the legislature and was presented to the governor on the 28th. It talks about the process for someone who wishes to appeal their summary ejectment or the eviction as an indigent. Legally, the word indigent means extremely poor person lacking in basic resources. It also has language in there that stipulates the rights of the plaintiff, or in that case, it could be the landlord or property manager, to request that the appeal be dismissed. There's another bill, the House Bill 556, titled Tenancy in Common / e-Notary / Small Claims Changes, that was also presented to the governor last week and had language similar to that of House Bill 555 and Senate Bill 553. If you remember last year, this was a landlord-tenant rights bill that we were really concerned about, that we found to be dangerous. So some toned-down version of some of the language in that bill made it into this bill, which codifies the law of tenancy in common in North Carolina, but it also prohibits counties and cities from adopting certain ordinances, rules, and regulations that would prohibit landlords from refusing to pay rent to tenants because a tenant's lawful source of income to pay rent includes funding from a federal housing assistance program. Now, this piece of legislation does include a few scenarios in which a sort of source of income protection is okay. So we will definitely make sure to include a link to that legislation so that part is clear. And this law also includes clarification around litigation costs in an eviction or summary ejectment matter. So we're going to continue to keep an eye for pieces of other bills that will make it into other bills throughout the remainder of the session once they come back. They're set to come back on July 10th. And we've also included a list of legislation that has an effective date of July 1, 2024, which is yesterday. Last but not least, I want you all to check out the Out of Reach Report 2024 that was released by the National Low-Income Housing Coalition. We did a piece summarizing some of the findings for North Carolina in particular. This is a big report. We use this data, the housing wage data in particular, for our county profiles. And so these housing wage numbers are what we're going to be using for our 2025 county profiles. There are lots of great events coming up, including our 2024 North Carolina Affordable Housing Conference, September 5th through the 6th, at the Raleigh Convention Center. So if you have not registered, really recommend that you do so. There are several other events happening as well. Our partners in the West, Land of Sky Regional Council, are having their second annual Western North Carolina Regional Housing Forum on August 9th from 9 a.m. to 3 p.m. We will be there. And check out the other events that we have listed in the call notes, as well as what we've been seeing in the news and other reports and resources. Another big shout out to Daniel. Thank you so much for joining us. Remember, you all, if you want us to talk about anything in particular or have any questions, don't hesitate to reach out. I hope you have a great rest of your week, and we'll talk to you next time.